Good morning. This is the matter of Fitzgerald versus Fitzgerald. Mr. Fitzgerald representing himself. The defendant is represented by Deborah Coletti. We're here on the plaintiff's motion for custody, which the court has reviewed. And there is also a response that's been filed. I've reviewed that as well. I think even though it's Mr. Fitzgerald's burden, I will allow Ms. Coletti to briefly place their position on the record first.
Thank you, Your Honor. Thank you for reading our response. Essentially, the allegations made by Mr. Fitzgerald are either old information or false information. We provide a proof of the 911 call he made where he did verify that Ms. Fitzgerald was having a seizure. 2, we have the lab report from the hospital after her seizure in which she had a 0 ethanol. And 3, we provide the text messages where we proved that she did not have custody of the child when he called and asked for a breathalyzer. I think the bottom line is this is a case where Thoreau versus Doro would apply, where we have a parent that has temporary need for Mr. Fitzgerald to provide custody, but this should only be temporary. So we're asking that you adopt the proposed order that we provided, which would allow her to have parenting time every other week and supervised by her parents while she's recovering in Indiana. And then Mr. Fitzgerald would have Ainsley, the minor child, until such time as she's recovered and can resume her 50-50 custody. Thank you.
All right. Thank you. Mr. Fitzgerald, any response to that?
Yes, ma'am. First of all, the 911 call, I was just describing the manner of the defendant. This is an alcoholic seizure that I've witnessed several times during our marriage. So that it doesn't play into point. However, the ethanol level that the defendant has admitted to this court, for them to say that there's 0 is actually untrue. The ethanol level collected on August 26th at 1:27 a.m. is a 200 milligrams per deciliter, which occurs to a 0.2 blood alcohol content. Ethanol blood high toxic is a 400 milligrams through deciliters. That is a 0.4 blood alcohol contact. This has been confirmed with Dr. John Kopchik, a former urologist, retired now. 0.08 is drunk driving according to the state of Michigan, which
I'm going to object, and Mr. Fitzgerald is one out of, and 2, he doesn't have any proof that this is true.
All right.
I provided.
Let me hold on, Ms. Coletti. Hold on. Mr. Fitzgerald, you cannot testify as an expert. You are not an expert in this field, and that is not something you can testify to or state, okay?
Your Honor, I am repeating what was given to me with her. The submission is that she has.
Mr. Fitzgerald, I need you to hold on and listen to me, okay? That's yes, what somebody else told you, or what something else that you read that somebody else prepared. That's all hearsay, okay?
Yes, ma'am.
I basically just want you to, in very simple terms, tell me what your position is.
The position is that she has presented that there was ethanol in her bloodstream, and that goes against the court order of her not to have any alcohol in her system while she's drinking.
Okay, let me ask, the proposed, at least temporary...
A decisive ruling brings clarity but raises the stakes for both.
...resolution that's been proposed to the court is that she have supervised parenting time every weekend from Friday after school till Sunday at 5 p.m. in Indiana with either of her parents as a supervisor. So it's supervised parenting time. What is your response to that?
I think that every other weekend, with flexibility due to her Girl Scout meetings and other school activities and birthday parties, should be allowed to make way to the every other weekend. I do not want to disrupt the child's social calendar to accommodate the defendant.
Ms. Coletti.
And I would just say that if there is a special event, he can inform Ms. Fitzgerald and she can just stay in Grand Rapids with her parents to make sure she gets to Girl Scouts or a birthday party, but she shouldn't go from 50-50 to seeing the child every other weekend when this is only temporary, she is getting the medical intervention she needs for her seizures. We're not denying that she's an alcoholic, but she is recovering, and I don't think we should punish her by not letting her see the child every weekend when it's supervised by her parents, and the child will be safe. And we will certainly accommodate anything the child, if she is an activity, we'll make sure that that's accommodated.
Well, again, because this is temporary and it has been a 50-50 situation, the court is satisfied that supervised parenting time pending the outcome of a front of the court investigation recommendation is appropriate. So the court will adopt the proposed order provided by the defendant, which would be that the parties continue to exercise joint legal custody, that defendant shall exercise supervised parenting time. I do think it is appropriate every weekend from Friday after school till Sunday at 5 p.m. with either of her parents as the supervisor. And again, I will send this to the front of the court for them to make a recommendation going forward, because I believe this does provide proper cause or change in circumstances where the court should be looking at this whole situation. And
Thank you,
I'll
Anna.
indicate that the parties are to split the cost of the investigation with the front of the court, 50-50.
Do you
All right.
want me to redo the order then, Your Honor, or will you do the referral to front of the court and you'll just sign the order we
I'll
submitted?
sign the order that was proposed, and I will do a bench order to the front of the court.
Okay, thank you, Your Honor.
All right, thank you. We're adjourned.
Thank you, Your Honor.
This is the matter of Riley versus Riley. We are here on the defendant's motion for an order for plaintiff to refinance the mortgage and remove his name as mortgagee. And Ms. Baker.
Thank you, Your Honor. This was a default judgment of divorce. My client did not participate in the proceedings. Miss Riley did the judgment of divorce. When she did it, she awarded herself the home, but did not put any provisions to remove Mr. Riley from that mortgage. And it's just not equitable for him to be tied to that mortgage in that house indefinitely. It's been a couple of years since they have been divorced. Miss Riley has indicated that she would attempt to refinance, but has never followed through with that. And Mr. Riley can't move on or get a new mortgage of his own without the release of him being from that lien. So we're just
Drama unfolds as a surprise refinance approval drops. Just when things looked stuck,
asking for her to have that home taken out of Mr. Riley's name so that he can move forward and not be tied to that home any longer.
Okay. Ms. Riley, do you have a response?
I have been working on it the past 2 weeks, Your Honor. I have been to the bank. I actually, as of yesterday, finally got approved to refinance. The difference has been I've been waiting to try to do it on my own. That has not been possible. The bank told me come back in another year. And getting advice from other people, they've said the court won't give you a year. So I found a co-signer and finally got approved yesterday.
Okay.
To refinance.
Do you have a letter or something to confirm that?
I have like the emails corresponding with the guy. It's at LMCU.
Okay. Just the
with the-
email that says you're approved, I think, is probably what Ms. Baker would like to see.
Okay.
All right. And then
yeah.
updates as you go,
Sure.
so that she knows if there's delays and why.
Okay.
All right.
Yeah.
Did they give you any sense of how long it would be to close?
The estimate was probably 2 months, but then they were worried that that paperwork that you are looking for to verify would be another month or so. So I don't know. That
Okay.
I'm just giving what I've gotten advice from a lot of various people.
Well, you really should be consulting with an attorney and not various people. So, because these are all legal issues.
I understand.
All right. Well, I believe based on what I've heard, I'm going to grant the motion, order that Ms. Riley refinance the home within 60 days. I'll
Okay.
reserve the request for attorney fees. If Ms. Riley does not refinance the home within that time, then the court may be inclined to award attorney's fees to Mr. Riley. And again, I would just encourage you, Ms. Riley, to communicate with Ms. Baker.
Okay,
She's not unreasonable. She just
Okay.
needs proof of what's going on in communication. Okay.
okay, I can do that.
All right. And Ms. Baker, you'll prepare the order.
I sure will. Thank you.
Judge sets 60 days, warns of fees, and delivers the final word. The courtroom closes with firm orders and a warning not to fail. Don't forget to like this video, subscribe to the channel, and we'll see you in the next video.